Good afternoon, everyone. Welcome to our Epilogue Society webinar. It's just a couple minutes to 12, so we're just going to wait for some participants to join us and begin in a couple of minutes. Good afternoon, everyone, and thank you for joining us this afternoon. Just going to give it a couple more minutes for some people to join us and then start in a minute or two. All right. Good afternoon, everyone, and welcome to the Calgary Public Library Foundation's Epilogue Society webinar. My name is Alexandra Runke, and I'm the Donor Relations and Legacy Officer here at Calgary Public Library Foundation. If you don't know anything about us, we are a registered charity, and our sole purpose is to provide support to Calgary Public Library. Since 2013, our amazing group of donors has helped us raise more than $80 million in support of the library's innovative programming and services. I'd like to begin today's webinar with a land acknowledgement. With gratitude, mutual respect, and reciprocity, we acknowledge the ancestral home, culture, and oral teachings of the Treaty 7 signatories, which includes the Siksika Nation, Piikani Nation, the Kainai Nation, the Îethka Stoney Nakoda Nation, consisting of the Chiniki, Bearspaw, and Goodstoney bands, and the people of Tsuut'ina Nation. The city of Calgary is also homeland to the historic Northwest Métis and to the Otipemisiwak Métis government, Métis Nation Battle River Territory, Nose Hill District 5, and Elbow Métis District 6. At Calgary Public Library, we celebrate stories, the stories of the community and the land that we live on. We serve the community on Winchispa, Kusitsi, and Moginstis, which describe the gathering place where the Bow and Elbow rivers meet. We respect all people who share, celebrate, and care for the Treaty 7 territory of Southern Alberta. And we honor the original caretakers of the land who remind us of the ongoing histories that precede us. We recognize our shared responsibilities going forward to help bring everyone together on this journey of truth and reconciliation. So welcome everyone again to today's Epilogue Society webinar. If you're new to these webinars, the Epilogue Society webinar series is a showcase of experts sharing their knowledge to help enhance your financial literacy around future planning. And we're so delighted that you have joined us today. And in fact, wanted to highlight that November is recognized in Canada as Make a Will Month. Over half of Canadians don't have a will. And I just want to let that kind of sink in. I find it just staggering. And this month really serves as a reminder of how important it is to take the time to express intentions in your will and to protect your personal and financial wishes. So I'd like to just take a moment and acknowledge that you're all here joining today, thinking about your future planning and the legacy that you want to leave. At the Library Foundation, our Epilogue Society donors are those who have decided to leave a gift in their will to the library. This creates an incredible legacy for the donor and is an ultimate expression of their values. It also creates a real lasting impact on the community, and it supports the library and the needs far into the future. So we're so incredibly grateful to this very special group of donors for their support. And we're delighted to host this series, and I really hope that it's going to be very helpful for you as you start your planning. To lead our discussion today and share common misconceptions and mistakes and how to avoid them is Craig Tervit. Craig is the founder of The Last Word. Craig completed his undergraduate degree at the University of British Columbia. He moved to Calgary in 2010, fell in love with this city, and has lived here ever since. He met his wife Jen in law school at the University of Calgary, and they now have 3 wonderful young daughters. Craig founded The Last Word in 2015 after realizing how much he loved to work um, with people one-on-one to represent their families and plan their legacies. Just before I hand things over to Craig, I want to just go over a few housekeeping notes. So we are recording this webinar, and you're going to receive a link to the presentation in a couple days' time, so you can utilize everything that's talked about today into the future. And we're going to leave some time at the end of the presentation for a Q&A. So if you have any questions for Craig or for the foundation team, please write them in the Q&A box, which you can access by clicking the chat button at the bottom of the screen. And lastly, we'd appreciate you completing a short survey at the end of the webinar. We're going to share a link to that on the screen at the end, and it will also be in a follow-up email. If you complete this in the next week, you'll be entered into the chance to win a prize pack, courtesy of the Penguin Random House Canada. So it's a special book prize pack. This survey is going to allow you to just tell us how the webinar was for you today, and also share ideas if you have any for future topics. And it's going to help us inform these webinars as we move forward. Okay, so Craig, I'd like to just hand things over to you without further ado. Please take it away.
Perfect. Thanks so much. I'm a huge supporter of the library, and myself and my kids are always, we do our weekly trip, and it's it's a highlight of my week, and it's also something where it's great that I'm getting them into something that is, not just them sitting on screens or doing anything like that. It's it's always great in the environment. I do think the libraries nowadays are so much more vibrant places than when I was younger, and they were just, you go there and you can't make any noise and that kind of thing. So I really enjoy supporting the library. So I really appreciate being here. I could go on at length, but I should probably start my presentation. So let me quickly share it here. Okay, so yeah, here's basically what I'm going to talk about today is just a little bit of, in my practice doing wills and estates, and that's exclusively all I do. So I see a lot of the common understanding of what people think, uh, the way they feel that wills and estates work, but realistically, oftentimes that's not the case. So I thought it might be helpful to go through some of the things that I come across frequently where people think have a misconception about the way things work. So briefly, what those are. First, very, very commonly, people will come in with the understanding or the feeling that no matter what they do, the main goal of any estate planning is to avoid probate because, for various reasons, and we'll go through those. Tied into this often is the idea that, look, if anything that goes through the estate is going to cause tax problems. And it's certainly a lot more nuanced than that. Additionally, people often think that the best way to go about solving all of these problems is to transfer everything to the beneficiaries, quite often their kids, as a way of avoiding any sort of tax problems, any of the other issues related to probate. And then lastly, it's just the idea that the estate plan is exclusively about transferring dollars and cents. And it's certainly a bit more than that. So, very first, the people come through the door, and they're always, there's a lot of literature out there, a lot of it based in other jurisdictions, where the main concern and the main thought is, oh, how do I avoid probate? And the main reason is that probate is going to be a bit of a disaster. And so let's sort of unpack that about what the perception is about dealing with probate. And maybe very, very quickly, I should just touch on, for those of you that don't know what probate is. You've certainly, I'm sure, heard the term, but oftentimes people don't actually know what it means. So probate actually comes from a sort of Latin word that comes from the word we use for prove. So it's proving that the will is valid, that the executor that's named there is allowed to act in that role, and that the beneficiaries named are, supposed to be getting what they're getting. So that's all it really is. It's a process that allows, we'll have the court issue an order saying that this is the will, this is who's in charge, and here's anything else, in relation to that, maybe some restrictions or something like that. So the perception of what probate is and why it can be a disaster is that, no access to funds. So the idea that the executor won't be able to get access to any of the money, it'll be locked up for years, it can definitely be a concern. The timeline, I mentioned the years there. Probably everyone has heard a story or two about probate taking years and years, and everything being unable to be distributed to beneficiaries for an extended period of time. Costs, similarly, the price of probate can sometimes be confused with other things as well, but certainly fear of how much is this going to cost if lawyers are involved, and if it's this lengthy process with various professionals, etc. Complications, if someone sues the estate, or if the bank isn't cooperative, or there's an issue with the will, or something along those lines, there can be complications for sure. And lastly, taxes. We sort of touched on that already, but we'll go into a bit more depth on that. So that's the sort of the thing that people assume is going to be a concern. And so just to give you an idea, I got this image here by asking ChatGPT to draw a probate monster. And then the next slide is the probate reality, which is slightly not quite so terrifying. And I asked it to make it the same image, but 20% less intimidating. But I'll show, as you can see, it's I think much more than 20% less intimidating. But anyways, it looks quite nice. So unpacking those ideas about probate. So having no access to funds, the idea that maybe the executor will have to pay out of their own pocket for things like a funeral, etc. This can be the case. Planning can certainly help. And also educating your executor can help. So oftentimes, the ability to access those funds can be solved, with maybe one smaller account that is joint with the executor, sometimes a checking account. You can make it clear in the will that that account isn't supposed to transfer to the executor as sort of their own asset, but they are given access via that joint account, so that they can pay for funeral expenses, etc. Another thing, just in terms of the education side, an executor can usually, as long as there's a will and as long as it's quite clear what is going on, pay for estate expenses directly from a bank account that's in the deceased's name, as long as it's coming directly out of that account. So if there's even before probate's granted. So if there's an account and there's a funeral expense that's $15,000 or something like that, as long as they take the death certificate and the will and all that stuff in, and as long as they then provide the invoice to the bank, they can usually issue a check directly from that account if it's clearly an estate expense. the difficulty that executors tend to face is that they don't they're not aware of this, and so they pay for it out of their own with their own credit card, and then they take that to the bank, and then the bank says, well, I can't just cut a check to you even though you've provided me with the receipt, because that can be a bit more tricky. So it's knowing in advance how to deal with this, and that can certainly help on that side of things. In terms of the timeline for probate, the tricky thing is when we're talking about the timeline is maybe a misunderstanding of what takes time and what we're talking about when we're talking about the timeline. So getting a grant of probate, so for a pretty typical will, in Alberta, a standard grant now only takes 2 to 3 weeks to get that. Does it mean the estate's wrapped up within a few weeks? No, that is something where the grant allows the executor to sell things from the estate, to manage the bank accounts, consolidate everything, deal with taxes, all of that kind of stuff. And it certainly, usually they're not distributing anything until after all of the taxes have been dealt with, filed, paid, processed, etc. That stuff is going to be required whether there's probate or not. So that timeline of thinking, oh, well, it'll take a year and a half to deal with all of the taxes and manage everything. Even if there's no probate, someone's going to have to do that and manage that. So when we think of, literally just getting the grant, that can be fairly straightforward. And the things that take longer are generally things that will have to get dealt with in that timeline anyways, and whether there's probate or not. So you might be dealing with that timeline even if there's no probate required. In terms of costs, in a lot of jurisdictions, probate costs are set up, there's a court processing cost, like the actual probate fees through the courts. In some provinces, it's as high as 1.5% of the estate. So there, it can be a real concern especially if you're dealing with a multi-million-dollar estate, you're paying a lot of money just to have it processed through the courts. In Alberta, however, probate fees are low. I always jokingly say, even though it's true, that Alberta is the cheapest place to die in Canada. So it's our probate fees aren't a percentage. They are somewhat tied in a sort of step up sort of thing to the value of the estate, but it's the top value that it doesn't go higher than is $525. So when we're talking about that portion of the concern about probate, there are plenty of jurisdictions where they're trying really hard to avoid probate fees. But in Alberta, it's less of a concern, especially in the higher end estates. $525 is not all that much. Certainly, a lot of the literature that you might see online is based on how things work in the US, and in some of those places that can be very expensive. There is also the cost of, dealing with the probate application, getting legal advice, etc. I would always advise anyone in any kind of, if you're an executor for any kind of estate, to get legal advice, at least just to understand what you can and can't do, because executors are personally liable for any decisions that they make. So it's always important just to make sure that you're doing things the right way. The fees for legal advice on that can kind of vary, so it might be worthwhile shopping around a little bit. But overall, it's not prohibitive. Complications. These can still occur. That's unfortunately not something where I can say, don't worry, complications can't happen. I will say that sometimes complications can occur regardless of whether there's probate or not. And similarly, probate actually sets a sort of timeline in place where someone will have a limited period of time to contest things or fight over the will. So sometimes if it's a complicated scenario, it might actually be best to go through probate, because then you have followed all the required steps. And if someone doesn't challenge things within a period of time, then the executor can actually be, safe to distribute everything, because there hasn't been anything done in that regard. So, yes, going through the will, there can be circumstances where it's best to avoid probate if there's a particular risk, but that's really on a case-by-case basis, and it's certainly not a general thing of avoid probate because of complications. Lastly, taxes. A lot of people think that if the estate is going to go through probate, it will mean that there will be more taxes payable. And generally speaking, that's not the case. We can discuss that in more depth. So just as soon as I get to the next slide. So now, next part that we're going to talk about is taxes. And more specifically, estate taxes. And then even more specifically, estate taxes in Canada. So what are we looking at when we're talking about this? Um, a lot of people think of estate taxes and maybe what they have in their mind is not really the reality. So when we're talking about estate tax, technically speaking, Canada doesn't really have an estate tax. Um, in some places in the US, for example, there is quite literally a tax on the sort of bottom line amount, times a percentage of this is the value of the estate, this is what gets paid. Or sometimes people were talking about estate tax and they're thinking of the sort of probate fees that we just talked about, the 1.5% potentially in some provinces. But there isn't really an estate tax. So when we're talking about that, what are we talking about when we're saying estate taxes? What there is in Canada is capital gains. So if you pass away, all of the assets that you have are calculated as if they are disposed of, essentially sold for value at the date that you pass away. And then capital gains are calculated as, have you made money on that? If so, then capital gains will come due. A portion of that will go onto your tax return. When we're talking about capital gains, I guess the one exception to that is that your registered accounts, not TFSAs, they're tax-free savings account. The name actually is true. But on things like your RSP, your RIF, your LIRA, things like that, that are all, if you really think about them, they're pre-tax dollars. So you've never paid income tax on them because, you received funds and then you got a tax return on the amount that you put into your RSP. That is effectively removing the tax from that. So it's all pre-tax dollars. And so what happens is when you pass away, that RSP is dissolved as if you took all the money out on the day you passed away, essentially. So there's now for the capital gains and the RSP, all of those, there are ways to, there's exceptions. Certainly anything going to a spouse, the RSP has a rollover, which it can go into your spouse's RSP, and then no taxes are payable at that point. However, it's still pre-tax dollars for the spouse. Capital gains, similarly, there's usually no capital gains on something going to your spouse, but it is when it goes down to the kids, then if that's what you're doing, or if it goes to anyone who's not a spouse, typically, there's always exceptions with taxes. But typically, then there will be capital gains come payable, and the RSPs will all, every dollar there will count as income. So if you have a $1 million RSP, if you're lucky enough, then you might be paying close to $450,000 in taxes on it. So it can be a huge hit, especially if you're not expecting it. RSPs, I always say, are really designed for retirement savings, and they're not as well designed for estate planning. Doesn't mean that they're not useful tools. It just means we have to be aware of how they work and when, how to factor in that potential tax hit. Capital gains exemptions, I already sort of touched on, but obviously your primary residence is a capital gains exemption. So if that's increased in value, you're not paying capital gains on that. There's other exemptions as well, lifetime capital gains exemption if you have a business, etc. But it's important with all of those to sort of speak to your accountant or a wealth professional in some capacity about how that all pieces together for you. And then lastly, I see lots of people look at it and think, okay, well, if there's going to be a big capital gain when I pass away, maybe the best thing I can do is I'll make some note that it's to be sold to my friend for $1 or something like that. It's not actually the value that is being it's not the value that you're selling it for if you sell it. It's the value that it holds based on an independent appraisal. So if you have a cabin, so it's not your primary residence, you bought it for $100,000, now it's worth $500,000. That's a $400,000 capital gain. You can sell it for $1, but there'll still be a capital gain of $400,000 because that was the value when you sold it. It doesn't really help to sell it for less than value. Maybe if you sold it for, slightly less than value, that could be deemed to be what it is, but it's not something where you can just avoid it by selling it for less. Okay, next, just wanted to touch on when we're talking about things going in the estate or out of the estate, what do I mean? So in the estate is usually anything that's covered by the will. So that's the general plan for the bucket of everything that is not already transferring. So what does transfer outside of the will? Typically, joint accounts. There's some complications around that sometimes, but typically, if you have a joint account with someone, you pass away, they will own it outright after you pass away. Insurance, things like life insurance, as long as there's a beneficiary named on them and that person's alive, it'll go to them. It won't go through the will. Similarly, with registered accounts like your RSPs, TFSAs, things like that. Joint properties, it's always important to note that when we're talking about those, it's got to be joint and in something called joint tenancy, which is just saying that it will transfer, your interest in it will transfer when you pass away to the other person. Otherwise, you might own half of it and your half would still be probated, etc. So the exact language on the title to your house, if it's jointly held, is very important. If there's an existing trust, anything that's in a trust you don't actually own typically. So that is usually transferring outside of the estate because it's not even a part of your estate because you don't own it. And then lastly, some corporate assets, there's ways that they can transfer outside of the estate as well. The other thing that people sometimes decide to do is, following up on that idea of people trying to avoid capital gains is, or trying to avoid probate is, how do we make it not just outside of the estate, but completely, not transferring on death, but transferring even more outside of the estate when, early. So typically we see this with parents deciding to do an early inheritance to their kids. If and early inheritances can be helpful and can be disastrous, and it really depends on how you do it and understanding how it all works. So a quick discussion on the positives and negatives of doing an early inheritance. We did talk about the capital gain side. The positive or the negative from a capital gain side is if that same condo or cabin we were talking about with a $400,000 capital gain, if you just transfer that to your child, and it's just an outright transfer, yes, you avoid dealing with capital gains in the estate, but at the time of transfer, that's a disposition for the sake of capital gains. So you're actually incurring that now. So keep in mind that if you're doing a transfer and you're gifting something like that, the person who's transferring it should be putting on their taxes that there's a disposition of that asset and what the current value is, and therefore taxes will be payable. And if you don't declare it now, it might not come up on your estate, your taxes now, but it may be something where from an estate perspective, suddenly it comes up. Oops, sorry, I'm getting ahead of myself. Sorry, there we go. From an estate perspective, they may have to deal with it at the time that they're dealing with the estate, which is always not fun because there might be back taxes payable and penalties and things like that as well. The benefits from a capital gains perspective, if you have a child, for example, who doesn't have a house, they don't have a primary residence, if you transfer assets to them and then they use that to buy a house, you may have some capital gains now, but the good news is as their asset is growing in value, there isn't going to be a disposition when you pass away, right? So, you give someone 50 grand now to purchase a house, that then is something that is, if their house is increasing in value over time, and then you pass away 20 years from now, that 50 grand may have benefited them much more than the 50 grand that it took to, you know, than the 50 grand that you provided. It could have grown significantly, and it's not something that on your death there's going to be capital gains associated with it. Um, it's also can be a benefit to provide something for kids at a time when it's more impactful. So there can be circumstances where, quite commonly, if someone's just starting out and they are in their, mid 20s or 30s or something like that, getting a gift can be quite beneficial to them early on in a way that if they're in retirement when you pass away, getting that same gift is less helpful and less impactful on their life. Um, Now, with all of that said, there are risks to doing it early, not just the capital gains issue, but I've certainly seen it where with some people have mentioned that they've provided too much essentially to their kids. They calculated what they thought they would need, and they gave everything else to their kids. And then it turned out that they either outlived what they thought they would live, or the expenses were more than they thought, or their investments didn't do as well. And then they were in a position where they were getting a sort of monthly allowance from their kids, but it really altered the dynamic of their relationship, even though they were getting an allowance from their own money that they'd given to the kids. So, the independence was somewhat lost there. And just because they were trying to benefit their children early. And so anytime we're doing this, it needs to be, it's not an absolute positive or an absolute negative. Anyone who's telling you either of those probably either is misinformed, or they're angling for something. Like if your child says there's no downside, they're probably just trying to get some money out of you. But you know as long as you're going into it with eyes wide open and being cautious and not going over the top, it can be quite beneficial, but it's something to always consider and just make sure that you're doing it in a way that's not going to put your well-being in jeopardy down the road, or impact your relationship that you might have with those people. Um, okay. Lastly, we were talking about estate planning and how I made the comment in that first slide that estate planning was not necessarily just about wealth transfer. And so a lot of people see estate planning and writing a will as just sort of, how do I transfer the money that I have to the people I want to give it to? And I'm telling you that, in terms of it being exclusively that is false. But also, in a very other real sense, that's also very, very true. And what do I mean by that? I think the focus of estate planning, because it is a bunch of wealth professionals usually, so you're talking to your accountant, you're talking to your financial advisor if you have one, you're talking to the lawyer. It all feels very money focused. But I think anytime that there's an estate and you're transferring something to the next generation or to other people that you care about, this is actually a sort of wealth transfer based on not just financial wealth, but just generally the wealth of your relationship with that person, the wealth of your experience and your values that you're passing on to other people. So I think any really good estate plan is trying to factor in that part of it, not just what's the most efficient way to give money to people. And that can be obviously a big concern. But doing that in a way that is also setting people up for life, in terms of setting them up to be successful, but also setting them up to be the people that you think they can be. And so what do I mean by that? Because that sounds like obviously a lot to unpack. When we're trying to maximize wealth transfer, and again, that's sort of in this slide, I'm talking about both kinds. So, the sort of emotional wealth and the wealth of experience that you have, and then also the financial wealth. I think it's important to communicate with beneficiaries. So having things set up properly, having things clear. So a lot of that comes down to having a plan that makes sense. Again, to the next point, having a plan that makes sense, having the documents that you have speak to what that plan is in an accurate and clear way is very important, because you can imagine you can have all of these intentions of having everything set up to maximize the dollar amount that your kids are getting, let's say, and and with the idea that they would do wonderful things with it. But maybe your documents aren't set up in a way that actually allows that to happen. Maybe it's, you know, done poorly and it leads to some sort of legal fight that leads to delays and leads to ill feelings and leads to everyone feeling like, you know, everyone else was out to get them, and they need to be very, very cautious with their own money, and not sort of open about things. Like, I really find that having clear communication with beneficiaries and with the executor and all of those positions can really, really help set them up, A, to be successful in the role as executor, and B, to sort of be aware. Like, it makes great theater when you have in a movie the will reading, but those things, theater is not what you want for your estate. You want things set up in a way so that there are no surprises. Everyone's aware of what they're getting. Everyone's aware of how it will go, and they just follow through with the way things are set up. Then there's no drama. There's, and everyone's relationships can benefit from that rather than deteriorating. Because that's always, to my mind, the biggest thing is, if you have multiple beneficiaries, is this going to be something that brings them together? And ideally, I mean, if you're transferring money to these people, hopefully it's something where you are making their lives better, which includes their relationships. So having that affected through your will and through the way everything is set up can be really, really beneficial to an estate. So what do I mean beyond just communicating with the beneficiaries and with people you've named? Having a clear understanding of tax rollovers, tax rates, talking to professionals, right? Putting insurance in place. So there can be some insurance, you can have insurance set up to help pay for taxes. You can have insurance set up to make a charitable gift to help offset taxes. There are quite a lot of different things that you can do with life insurance. If you qualify, it's got to be at the right time for you as well. But there's options there of ways to maximize the value of what's there. And then, we already talked about the primary residence exemption. Capital gains, we did talk about, but something important to note is that if charitable giving is something that is valuable to you in your lifetime, and you choose to do that in your will, you can do it in a way that's actually more beneficial than it typically is during your lifetime. So, for example, if you have an investment that has increased in value significantly, and there's a big capital gain that's owing, right? If you put that, if you make sure that gift is going to directly to a charity, and it's a qualified charity. So let's say that investment in your will, you say that investment is going to go specifically, that account, let's say, is going to go to a specific charity. Not only is the capital gain from that charity not applicable on your final taxes, but also the value of it can be, the fair market value of the investment can be a charitable, you get a charitable gift receipt for it for the estate. So that can be tremendously helpful. Certainly, if you sort of run the numbers on something with a large capital gain, and then not only do you not have to pay that gain, but you also get as a tax credit the amount that it's worth. That is huge. Important to note that one of the things that I haven't mentioned yet, but is if you have a will in place, not only does it help with the clarity, the planning, the communication, like it sort of pulls everything together, but from a tax perspective, having a will means that your estate qualifies to be a graduated rate estate. And so what does that mean? It means that your estate for the first 3 years will, any income coming into the estate will count will get taxed at a graduated rate, just like an individual does. So if your estate, has some investments that haven't yet been wrapped up, the first, things are going to be taxed with no tax on the very bottom level, then only minimal amounts, and it increases from there. But it's certainly a lot better than if there is no graduated rate, then the first dollar of income is taxed at the highest marginal rate. So that's more of a concern. And the other thing to mention is that if you give a charitable gift in your will, then if it's a graduated rate estate, it can be applied to your income tax from the year you passed away. It can also be applied to the previous year. And it can also be applied for any subsequent year of the estate. Sometimes these, maybe it takes a while to sell a house or something like that, up to 5 years from that date. So it can be really, really beneficial to make a significant charitable gift. And it can also help you to keep the, if charitable giving was something that was important during a lifetime, it allows you to sort of reinforce that through the estate while also making it more tax efficient. So that's a really helpful way to do that. I just touched on graduated rated estates. RSP beneficiaries, the same thing can apply there. You can make, if there's an RRSP that's going to incur a huge tax bill, you can actually gift that, name as a beneficiary. You can name a qualified charity, and it has the same kind of benefits. So really important to note those options and finding out what works best for you. And really just to make sure that the next generation or whoever you're giving your estate to can not only benefit, but also benefit from the values and things that were most important to you. So that's about it for my presentation for now. But
Thank you, Craig. Oh my gosh, there were so many incredible nuggets of information there. I know I learn new things every time we have these webinars. There's just such a wealth of knowledge. So thank you so much. I really want to dive into questions. I know that we've got several here. So let me just dive right in. Okay. All right. So, Craig, I understand that a handwritten will is still legal as long as it's witnessed. Is that right?
It's actually it's not, but probably not in the way you think. So in Alberta, and again, specifying Alberta, this is each province has their own laws around wills and estates and that kind of thing. But a handwritten will can be valid in Alberta as long as the person writing it writes all of it, signs and dates it themselves. That's it. It doesn't have to be witnessed at all. The important part being that, yeah, it's all written in that person's own handwriting. The challenge you can face with handwritten wills is if they're written poorly, there's not much, it has to have all the components of a will. The other challenge is that if someone wants to contest it, the witnesses serve a purpose when you have when it's not a handwritten will. They serve a purpose of saying, I was there, they knew what they were talking about, they signed off on it, and they understood what they were signing, and no one was holding a gun to their head to sign it. Whereas it's easier to challenge a handwritten will if you ever wanted to, because no one else is there to speak to what happened. So that's the biggest challenge you sometimes face with one of those is what happens there. So yeah, but you, technically speaking, for it to be a valid will, you only need it to be in your own handwriting, signed and dated, and that's all.
Okay, thank you. All right. I've got one here for the foundation. They're asking if you need a certain level of wealth to leave a gift and will to a charity. And the answer is no. And this is the beauty of leaving a gift in your will, is it's really accessible to everybody. Of course, we would encourage that you talk with your financial advisor, your family, to make sure it's right for your situation. But this really is accessible to everybody. There's so many options out there that you can tailor to your specific situation. I don't know, Craig, if you want to add anything to
Yeah,
that.
agreed. similarly, people will say, do I, if I don't have a lot of money, do I need to write a will? And it's usually yes, it's still a good idea. But in terms of charitable gifts, it's really just about what's important to you. So, if there's a charity that you've always valued in your lifetime or that value now, there's certainly no reason why you can't do that. It's oftentimes, people struggle with the idea of, well, these are the family members that are, biologically closest to me. Do I need to give to them ahead of everyone else? And from my perspective, everyone has a different idea on this, but I tend to think like the people that you're close with, in terms of your lifetime and the things that are most important to you are the things that you should be putting in your will. And there's no, unless if you have a child or a spouse, you need to make sure that they're taken care of. But beyond that, your estate it's your money and you should have it go to things and people that you value.
Right. Um, okay. We've got a lot of a lot of questions here. In a second marriage situation, what are the best ways to ensure that the surviving spouse is provided for during their life?
Um, so that is a big question. There's a lot of ways that there's a lot of considerations. I'm already aware this is a very lawyer answer where I'm like, well, it really depends. But there's a lot going on in a circumstance like that, and it really depends, what's the goal. So is it something where we're saying we want to maximize the amount we can give to the surviving spouse, or is it something where we want to do that but also provide significantly for the kids, or guarantee that when the surviving spouse passes away, it goes to the kids? There's a lot of different ways that you can set things up, and I wouldn't say any particular one is the right way to go. It's just a lot of balancing of, you could set something up like a trust where, for your spouse's lifetime, they get the benefit of all of the assets. And then when they pass away, the trust dictates that it all goes to the kids. So the spouse doesn't actually get the assets outright. That's great at protecting the assets, less great at giving the spouse freedom to do what they want with the money, if you were thinking of it as their money. So, that's one sort of extreme on one end. The other version is giving the spouse a fixed, like a portion of the estate. That's all they get essentially. But then the kids get something, the spouse gets something at that point, and no one has any obligation to provide to the other. They can if they want to, but they don't have to. There's positives and negatives to a lot of different options there, and there isn't really a clear, this is the best way to do it.
Mhm. I will just say that our contact information is here. So if you have questions that are more specific to your circumstance and you want to reach out, please do. So another question: can a single person leave their TFSA to a niece and nephew? How
Um,
can they get access to it right away?
yeah, so they absolutely can. Access to it right away might depend on the age of the niece and nephew. So, if you have a minor who's a niece or nephew, typically you can't gift financial funds like $10, you're probably fine. But if it's a $50,000 TFSA, you can't just gift that to your niece and nephew if they're 8, for example. However, if they're over 18, yes, you can do that. You can either do that in your will or you can do that via the beneficiary designation on your TFSA, because they are registered accounts and there's beneficiaries. If they are minors, you'd probably set something up in your will to say, it's going to go to my niece and nephew. Here's who's going to be in charge of the money until they turn 18. And then once they're over 18, you could just do it by the beneficiary designation. Or, I say 18, but 18-year-olds sometimes don't make the best decisions. So it can be in trust for longer than that, if you prefer.
Mhm. Okay. What happens if a beneficiary in a will changes? Oh my gosh, I lost the question. This big scroll. Bear with me just one second while I find it. What happens if a beneficiary in a will changes their name? That's interesting.
No, that's a great question. Names change frequently, and sometimes it's more dramatic than others. Like when someone gets married and their last name changes potentially, um, fairly straightforward. But as long as at the time that the will was written, that was the name of the person, so there's no question about who was intended at that time. Usually, all that's required is just sometimes, as long as the executor is aware and everyone involved with the estate is aware of who this person is, that can be a non-issue. It may require some minor level of, the name change document or proof that that was their name at the time that the will was written. However, you don't have to change your will each time someone's name changes. Similarly, we, for example, quite commonly put the city of residence of a person, just to be clear about who, this is this John Smith, right? But if that changes, you don't have to change your will each time someone moves, thankfully. 'Cause otherwise, there'd be a lot of work for me, but not ideal. Yeah.
Great, thank you, Craig. Um, are all expenses associated with death written down somewhere, or is there a checklist on government pages of what to do and in what
Um,
order?
yeah, I mean, when we're talking expenses are maybe different from the checklist of things to do. They can overlap, obviously, but they're two separate things. Um, Unfortunately, like there are some sort of checklists. Provided by the government, and there's books that sort of talk about what an executor needs to do. Every estate is a little bit different. So it's kind of like saying, hey, like as a parent, I'm trying to raise my child. What are the checklists of things I need to do? And either it would be an insanely long checklist, most of which wouldn't apply, or it's going to be a checklist of which some of it, there might be a lot more check boxes that need to be done depending on the circumstances. So there isn't really a master list. Um, but I would just say talk to someone who has, if you're dealing with an estate, talk to someone who's has some experience doing this and get a sense of the things that need to be done. From a tax perspective, for example, talk to your accountant, and the accountant can make sure that everything is sorted out and in that regard. But there's a lot of different pieces that don't necessarily all um, get easily put into a checklist, depending on how the estate looks, who the beneficiaries are, what all the assets are, details about the deceased, etc.
Mhm. Right. Okay, and we have time, I think, maybe for one or two more questions. Um, okay, so can a property asset be distributed as a charitable gift in kind of a percentage to different charities?
Um, yes, yes. Property asset, I'm assuming we're talking about real estate. Um, there's typically like when you're gifting real estate in a will, um, if you're giving all of it to a charity, it can be gifted in kind, and then the charity can do what they want with it. Sometimes there's charities that actually, will accept property and use it for different purposes, but quite commonly they're then turning around and selling it or doing something with it. Um, if you're if you have a property and you're gifting it to four charities, chances are those charities will ask the estate to just say, okay, well, sell it and then we'll deal with it from there. Just because it's very hard for four charities to be on title for a property, there's not much they can do with it. So you can absolutely do that in your will. If the intent is that the charities sort of share the property, it's probably not going to happen because it's just impractical for a charity. But the executor can sell the property, so you can put that in your will, and it just means that that's what would happen.
I can attest to that, yes. It would be very difficult to share it. And
Yeah, exactly.
um, and this kind of goes hand in hand with the last question here, which is, is it a good idea to share um, that you've left a specific charity in your will with that charity? And I will say, like, from a charity perspective, I would say absolutely, it's so helpful. It, first of all, while you don't have to, it ensures that your wishes are able to be fulfilled, because unfortunately, there are circumstances where if a gift is too narrow or narrowly designated, let's say to a program that maybe won't exist in 20 years from now, um, then unfortunately there might be times where charities are unable to accept a gift. So that would be such a shame. I mean, for the donor's intentions and wishes, and of course for the charity too. So I would say it's beneficial both for you and for the charity to share that information. And then of course they have the opportunity to thank you and involve you as a part of the donor family. So that is all the time we have for questions. Craig, I want to thank you so much again for joining us today for this awesome presentation, with just packed with awesome information. Thank you. And I hope it's all very helpful to everyone as you plan your own estates and future planning.
Thanks so much,
I
Alexandra. It was so great being here and really lovely chatting with you.
Thank you, Craig. And I just have a couple of things to close. I wanted to just mention that we have an upcoming event I'd like to invite all of you to. We have our Giving Tuesday fundraising breakfast. We host this annually on Giving Tuesday here at Central Library. And if you join us, you'll have a chance to see the library before opening hours, which is really fun and a rare opportunity. You have a chance to hear some amazing impact stories from our library patrons that have had the library impact their lives so deeply, and an opportunity to give back to our amazing library system if you so choose. So if you'd like more information, please contact me and I'd be delighted to send you more information. Just a reminder that if you're interested, please, in joining that chance to win the prize pack, please complete the survey. There's the link here. We have a wonderful book package up for grabs, and we're also going to be including that in the follow-up email as well. You have a full week to complete it. And then it also gives you a chance to share ideas for future topics that you would like to see at the webinars. So thank you all again for joining us. Huge thank you to Craig, and I look forward to seeing you all at the next webinar in the new year. Thank you.
Thanks again.